My name is Darren Senga from VLF's Dallas office. I'm joined here today by Joe Lanza and Dylan Fetterman from VLF San Antonio office. Welcome to another installment in Bethlehem Law Firm's video educational series. So Dylan, looking across these various levels of contractors, the general, the sub-sub, after they file their affidavit with the county records, that's not the end of it, right?
No, that's not the end. What they need to do after that is provide a subsequent notice that the lien has been filed, and that needs to be done within 5 days after the date that the lien was filed.
Okay, so effectively, then people, it sounds like the steps are, number one, figure out what relationship you have to the owner of the project.
Mm-hmm.
That's going to trigger which set of deadlines gets kicked in. Make sure you meet those deadlines. Make sure the affidavit is timely filed with the county.
Right.
And then send the notice out.
That's correct.
So, Dylan, now that we've got the various tiers of contractors understanding the basics of of how to file a lien, how to do it timely, why is it that liens are so powerful? What is it they allow a claimant to do?
So once someone gets a valid lien in place, it allows them to seek a judicial foreclosure of the property in order to get payment.
And any of those various tiers can do it, right?
That's correct.
So, Joe, as a general rule, if you're a subcontractor or a subcontractor and you initiate the judicial foreclosure, can you just do that by yourself? Do you have to give notice to any of the other people who could be a claimant? How does this work?
You have to give notice to any other parties, including subcontractors and subcontractors who may have an interest or be unpaid, and they have to be joined as part of the lawsuit.
So effectively, you end up with one lawsuit with everybody who could have a perfected lien claim on that piece of property, so they have an option to get paid, right?
That's correct.
So, Joe, when one of the subcontractors or the subcontractors initiates an action, can they just proceed by themselves, or do they need to bring other parties in?
They need to bring in all other parties who have a claim for unpaid goods or services on the project. So all those folks have to be brought into the lawsuit.
So all the other lien holders.
That's correct.
And amongst those various lien holders, the different levels, what's the general set of rules to determine who gets paid first?
Well, the timing of the work and the timing of the filing of the liens is not what's going to control when different parties get paid. Our statutes and case law elevate certain contractors and subcontractors above others, and that's probably a topic for a different time.
But as a general proposition, then, if there's a certain amount of money in the pool from the sale of the proceeds, from the proceeds of the sale, how do you determine who gets paid?
Generally, the funds are paid out proportionally.
So, Joe, as an aside, everything we've been talking about to this point has related to statutory liens, right?
That's correct. What we've been talking about are liens that are created by our legislature in Austin.
That's not the only kind of liens that exist.
That's correct. You also have a lien that's created by the Texas Constitution, and this lien is sort of the big bad of all liens. It's available only to someone who directly contracts with the landowner, that is generally the general contractor, and you don't have to meet any special provisions or any special time frames to file your affidavit of lien. The lien attaches as soon as you begin work on the property, and generally it takes priority over just about every other type of lien out there.
So, takeaway there is if you're a general contractor, know that you have a constitutional lien right as well, which is separate and apart from the statutory framework we've been talking about. Speaking of statutes, a lien is not the only set of rights that are at issue here.
That's correct.
You also have the possibility of retainage.